Hello, I am Dr. D. Bhuvaneshwari, Assistant Professor Selection Grade, HOD, Department of International Law and Organization, the Tamil Nadu Dr. Ambedkar Law University, Chennai. In this short lecture, I would like to throw light upon one of the quintessential topics of public international law, that is, custom as a dynamic source of international law. In the first slide, sources of international law, I would like to discuss what is source of law, its applicability in domestic and international legal system. Source means from where we derive the origin, either person or a thing. Similarly, sources of law refers to the origin from where the rules of human contact comes into existence and deduce their legal validity. The term has been used in different terminologies by different writers, as appears on the screen by Vinogradov. He explains it is a process by which the rule of law may be evolved. Allen, he explains sources of law means agencies through which the rules of conduct acquire the character of law by becoming definite, uniform and compulsory. Similarly goes the definition by Oppenheimer. Simply what we derive from the above learning is that sources of law refers to rules of human conduct that requires legal attestation for its validity. While we talk about sources and its applicability, there exists a sort of distinction between domestic and international legal system. The difference lies in the fact that international legal system operates in a horizontal zone of principle of equality of states enshrined in the United Nations Charter, and particularly in a decentralized system. But domestic legal system operates in hierarchical or vertical gradation of authority and essentially in a centralized system established by state structures like executive, legislature and judiciary. From this point of distinction, the topic sources of international law gains its own momentum of debate and deliberations. Now let us move on to the sources of international law. The authoritative statement of sources of international law is found in Article 38, Clause 1 of the Statute of ICJ. The article lists out the formal and material sources as well. It goes international conventions, or popularly known as treaties, custom as evidence of a general practice accepted as law, general principles of international law recognized by civilized nations. Fourth one, the judicial decisions and juristic works, which are referred as subsidiary sources. Now let us move on to the core component of this lecture, custom as a dynamic source of international law. When we define custom, it is the usage as hath obtained the force of law. The definition is explicative of its own evolution. Usage is the initial stage of custom. In any primitive society or a modern contemporary individual rights based society, rules of behavior emerge. These rules are followed by the group subconsciously and they are maintained by social pressures. Subsequently, when these rules derive their legal validity through statutes, judicial decisions, or proceedings. But the crux lies in the fact how far custom could contribute as an effective source of international law, as the essentials of the custom involves complicated elements. The custom's essential element contains two elements, that is objective and subjective. To explain in another term, it is a combination of material fact plus opinio juris sive necessitatis. Material fact actually refers to the objective element or an actual practice of the states that requires time duration, consistency, generality of practice and reputation. Opinio juris sive necessitatis is concerned with psychological factor or subjective element which is a belief based upon the legal obligation. We can further explore and understand these two concepts, that is material facts and opinio juris sive necessitatis, if we go to the next slide, which is explicative through judicial decisions, which sets out the parameters for a rule to evolve as a customary rule of international law. I would like to take for discussion one case law, Colombia versus Peru, where the rules have been decided based upon the elements what we have discussed in the previous slide. The facts of Colombia versus Peru, it is concerned with the extraterritorial asylum granted by Colombia to a Peruvian national, Jaya de la Torre. Colombia argues on the basis of existence of a regional custom among Latin American states regarding unilaterally deciding whether asylum could be granted on the ground of its qualification as a political offence. But the court held that there existed no constant or uniform usage regarding the unilateral qualification of the offence. It is quite uncertain and contradictory, as the practice does not amount to established international custom, as the practice pertains only to Latin America. Similarly, the following cases, Anglo-Norwegian fisheries case, North Sea continental shelf case, also explores the principles of continuity, repetition, the uniform usage which must be both extensive and virtually uniform. The final case on the slide, SS Lotus, which is one of the best among the series of Permanent Court of International Justice, talks about opinio juris sive necessitatis. As explained already, opinio juris is a belief that state should behave in such a way either to do or abstain as it is legally obligatory. The issue in SS Lotus concerned with collision on the high seas between SS Lotus, a French ship, and Bozgard, a Turkish ship. France referred to the absence of previous criminal prosecution by the states in similar situations, and from this deduced tacit consent in the practice. Therefore, it becomes a legal custom. But the court has held that only if such abstention were based on their being conscious of a duty to abstain, it would be possible to speak of an international custom. Thus, the essential ingredient of obligation was lacking, and the practice remained a practice, nothing more. Thank you.